Artificial intelligence. We're hearing the term daily, but here's something most leaders don't realize. It's not just about what AI can do, it's about who owns what was created with AI. A global race around AI is well underway. If you're embedding AI into your business, but you haven't aligned your AI strategy, you're vulnerable. Today I'm going to show you how this AI patent surge works, what it means for you, and how to protect your edge before someone else does. Let's look at the facts. The United States Patent and Trademark Office's Artificial Intelligence Patent Dataset shows that AI-related patent documents number in the millions when you include pre-grant publications. Globally, one report shows that since 2017, AI-related inventions have surged more than 800%. In other words, artificial intelligence inventions aren't just accelerating. The IP world is scrambling to keep up. If you're using AI in your business, you're already in the arena. The question is, are you playing down on the field or are you sitting up in the stands? You might say, Rich, I'm not inventing rockets. I'm just embedding AI in my service. I'm making it part of my workflow. That doesn't exempt you, it just makes this even more important. Why? Because patents are no longer just for labs and manufacturers. They're for systems, algorithms, processes, intelligent workflows. If someone else patents the core AI step you use, you're stuck owning a business built on someone else's moat. The value of your business, your defensibility, your exit potential, all lean on whether you treat AI as innovation to protect rather than capability to deploy. Here are the legal realities you need to face. 1. Inventorship. AI systems cannot be considered an inventor. Human inventive contribution remains a requirement. For example, courts in the UK recently ruled an AI system cannot be listed as an inventor. 2. Patentability. Even for AI inventions, you need to meet novelty, non-obviousness, and enablement requirements. Having AI in your product doesn't lower the bar or lessen the requirements for patentability. 3. Volume equals opportunity plus risk. The flood of AI patent filings gives you an opportunity to stake your ground, but also increases competition and may increase the standard that examiners apply. 4. Disclosure risk. If you launch your AI-powered innovation publicly before filing, for example, through a blog post, demonstration, or sale, you may damage or lose your patent rights in many jurisdictions. These aren't academic points, these are survival points. Now, let's talk about the mistakes I see inventors and founders make all the time when it comes to artificial intelligence and patents. Mistake number 1, deploying too soon. Inventors build something with AI, test it live, get feedback, maybe even launch a beta before they've filed a patent. The result? Their actions may be considered a public disclosure, and that can instantly expose your invention to competitors, or even disqualify it from protection in many countries. Mistake number 2, undervaluing their contribution. I hear this constantly. We used AI. The tool did the heavy lifting. But that's not how patent law works. The Patent Office only recognizes human inventive steps. If you're the one who defined the problem, directed the system, or improved the process, that's what's patentable. Don't erase your own role in the innovation. Mistake number 3, thinking small, filing in one country only. Many inventors say, we'll start with the US, and maybe we'll go international eventually. The problem is, by the time they get around to it, it's too late to file those international patents. And the fact is, you don't own a global innovation until you've protected it globally. These are inventors losing millions. Not because their ideas weren't brilliant, but because they didn't protect them properly. Here's what to do instead. Step 1, audit your AI use. Map where artificial intelligence is in your business. What's novel? What processes or decisions is the AI enabling? Document this in an invention disclosure before you launch publicly. Step 2, file to protect. Decide what you're protecting. The model architecture, the training process, the workflow integration. File early, even with a provisional in the United States. Get your timestamp. Consider global scope early. Remember, the filing race is worldwide. Step 3, transform IP into business value. Use your patents as proof of defensibility in fundraising or exit. Monitor competitive filings to stay ahead. Don't treat the patent like an afterthought. Treat it like a strategic weapon. When you execute this framework, you avoid being copied. You build value others will pay to access. Here's a simplified example. Company A builds an AI-powered service. They launch fast. They don't file. Within just months, multiple copycats emerge. Their product becomes commoditized. They have little defensibility. Company B builds a very similar service. Before public launch, they file a patent application, around the unique AI workflow integration. They launch. They use the filing in their pitch to investors, and they get capital to scale. Their AI becomes a barrier to competition. Which business would you rather be in? The difference is that one business treated their artificial intelligence as an innovation asset. The other business did not. If artificial intelligence is part of your business, stop the scaling rollout for a moment. Ensure you're not building on sand. Grab my book, The ABA Consumer Guide to Obtaining a Patent, then set up a strategy call with me. Let's map your AI innovation, protect the core, and turn your IP into value. Your ideas are your edge. Protect them before someone else does.